Blended families can take on many different forms, but will typically include a couple, be it married or in a de facto relationship, and one or both of them have children from a previous relationship, or the couple have children from a previous relationship and have further children to the new relationship. Blended families generally are caused due to separation, divorce, or death of a partner. The number of blended families in Australia is ever increasing, generally because the rate of divorce can be as high as 50%. Unfortunately, a lot of couples in blended families put their head in the sand when it comes to dealing with potential issues that commonly occur in blended families. A lot of the time, the conversation around wills and estate planning may lead to conflict, which some people try and avoid. Unfortunately, one or both spouse dies, and these unresolved issues materialise and most times ends in estate disputes. A common scenario is that if one spouse dies and their will provides that their estate is to pass to the surviving spouse, then on the death of the surviving spouse, the estate is distributed equally between the children and stepchildren. Although we are seeing an ever-increasing inquiry rate concerning what can be done when a spouse dies and the estate passes to the survivor, and the surviving spouse then changes their will to exclude the deceased spouse's children from benefiting from their estate, and they only name their children as beneficiaries in their new will. These changes are not limited to people's wills and estates, but also concerns the control of family trusts, family companies, and self-managed super funds. So when the surviving spouse passes away, the stepchild discovers that they are not named as a beneficiary in the will. As a result, they are eligible to bring a claim against the estate for further and better provision. Generally, because they've been excluded for no good reason, the court may hold the view that the step-parent had a moral obligation to provide for their stepchild and make provision for them, or in other words, they will give them a sum of money or an asset from the estate. To illustrate this, here is a common example. You have a couple that are married or in a de facto relationship, and for example, they have 3 children from a previous relationship. They had some wills prepared where in the event that one of them died, the estate would pass to the survivor, and if both of them passed away, their estate would pass equally to their 6 children, so to their biological children and also their stepchildren. In some cases, when the relationship commences, one spouse will have more assets than the other. During the period of the relationship, and for various different reasons, there can be tension between the family members, particularly between the step-parent and the stepchildren. When one spouse dies and their estate passes to the survivor, some years later the surviving spouse dies, although it is normally at this time when the stepchild discovers that their step-parent rewrote their will after their parent had passed away and had excluded them from it. In this scenario, the stepchildren are eligible to bring a claim against the estate. This type of scenario is ever increasing. We have been able to help many stepchildren bring claims against estates and be successful, where the removal as a beneficiary was of no fault of their own. If you think you may have a claim against an estate, please contact us today for a free claim assessment. Thank you.